So, John, as a litigator, one of the things that I deal with on a regular basis are separation boards, or whether it's an ADSEP board for an enlisted soldier or a board of inquiry for an officer. These are boards that are set up to determine whether or not that soldier should stay in the military. And the reason I deal with them as a litigator is because there are many trials. What it is there's a board of 3 individuals, whether it's officers and an enlisted person for the enlisted boards, or whether they're all officers for the board of inquiry. And it's at this board where you present your case. The government presents its case as to why they should be separated and what the characterization of service is, and then the defense is able to present their case at the same board, and then argue at the end for retention and characterization of service. And one of the things that is critical is that the officer or the soldier, the officer or enlisted soldier, seek the advice of the law office of William Helixon regarding these boards, because it's a trial. It's just a trial, not to a judge. And you need somebody who is a natural litigator who can go in there and influence those board members to retain you. Because let's face it, the people who are facing separation board are generally your senior officers and non-commissioned officers who have a lot to lose. Not only do they lose their career, but they lose their retirement. And if they lose their retirement, that could be, depending on how much service they have, in the millions of dollars.
As you said, Will, it's an opportunity for us as natural litigators to use the forum of a board to the advantage of our clients. We are able to call our own witnesses. We're able to cross-examine witnesses that the government brings. We are able to challenge evidence, the legitimacy of evidence that the government is able to provide. And we are allowed to make our own arguments and be as creative and as broad as we need to be, or as narrow as we need to be, depending on the case, and do our best at these boards for the client.
Right. So these boards are generally convened for officers by the GOSCA, or a general officer, and they're also convened administrative separation boards by an 06 commander or higher for enlisted soldiers. And they convene these boards to make a determination, usually based on an investigation that resulted in a GOMAR or an Article 15 or some other type of administrative action to determine whether or not to separate the soldier or not. And these procedures are outlined in Army regulation as to how the board is characterized and how it is carried out. And so the board answers a few questions. They answer first, did the soldier engage in the misconduct? That's a yes or no question. The second question is, does that misconduct warrant separation? Yes or no. The third question is, are they going to separate the soldier? And what characterization of service are they going to give? Honorable, general, or other than honorable? And, soldiers who are entitled to a board are those who are facing other than honorable discharge or have over 6 years of service in the military. So I would recommend that if you're facing a board, you need to talk to us. One of the things you should know also is what your rights are with respect to an administrative separation board. You're entitled to see the packet of information to you. You're entitled to review the evidence. You're entitled to know the witnesses that the government has that they're going to call and the evidence that they're going to produce. You're entitled to present your own evidence. You're entitled to cross-examine the witnesses that the government has. And you're entitled to make a case and make the argument. And if the board comes back and it has adverse findings to your position, they separate you, you can then appeal that directly to the GOSCA or the convening authority of the board, pointing out the deficiencies of the board and why the convening authority or the separation authority should not accept what the recommendations of the board are. I find that board practice is kind of like going to court, kind of like arguing in front of a judge, except the rules of evidence don't apply. There are very few rules that apply at a board, and so it's a pure advocacy event where it matters who your lawyers are.
Well, you've seen legal advisors at boards before. What is the role of a legal advisor at a board?
So the legal advisor advises the board president as to the legality or the merits of objections, right? Say, for instance, I object to something or the government objects to something. The legal advisor will listen to the objections and then provide the legal advice to the board president, who will then make a determination as to whether or not that evidence comes in.
And you said earlier, Will, that the GOSCA is the one who forms this board, and that being the general officer. And he or she picks the board members, is that correct?
That is correct.
And are you allowed to challenge those board members?
Absolutely. So in the very beginning of the board, we conduct what's known as Voir, and that is where I question first the legal advisor to make sure they're fair, neutral, and independent. And if they're not, then I challenge the legal advisor and try to get them replaced. But if they are, then the legal advisor stays in the room while I challenge individually, first the board president, and then in order of seniority, the other members of the board. And when I say challenge, I ask them questions. I ask them questions about their background. I ask them questions about their relationship with the appointing authority. I ask them questions about the relationship with the respondent. I ask them questions about the relationship with the government counsel. I ask them about what they know of the case. I ask them if they have any biases about the case. I ask them if they have any friends or family members who have suffered injustices like what's in this case. We do a full analysis based on the facts and asking each board member of those questions about whether or not they can serve as a fair and impartial board member. And if they can't, then we make a challenge to that board member, of which the legal advisor would make a ruling on. And then, of course, I could request that the convening authority, whoever appointed that board, relieve a board member based on cause.
So it sounds like all bases are covered if you represent a client at a board, both procedurally and substantively.
Well, absolutely. So understanding the procedural rules, understanding the substantive rules, and then having the ability to be a persuasive advocate is what's key in representation at these boards. We are the law office of William Helixon. We are your warrior advocates. You defend the nation, we defend you.